With that, I'll call the first case, People versus Kareem Swilley, please.
Good morning, Madam Chief Justice. Imran Syed of the University of Michigan Law School on behalf of defendant appellant Kareem Swilley. I'll reserve 3 minutes for rebuttal, if that's okay. Thank you. Your Honor, of the many safeguards built into our justice system to ensure a fair trial for criminal defendants, trial by an impartial judge is the most important. As the U.S. Supreme Court has recognized, so many of the other rights a criminal defendant has really depend on this primary right. This court therefore clarified an important standard in its 2015 opinion in People v. Stevens, noting that where a judge's conduct pierces the veil of judicial impartiality, a structural constitutional error has occurred, and the conviction must be reversed. To be clear then, Stevens certainly did not require finding a structural error every time the judge asked questions, or even every time the judge asked potentially problematic questions. Instead, the focus of the inquiry is on whether the judge's conduct pierced the veil of judicial impartiality, which occurs where it is reasonably likely that the conduct improperly influenced the jury by creating the appearance of bias. And that's exactly what happened here. I respectfully ask the court to reverse Mr. Swilley's conviction. Now, even though we're here on a structural error issue, I'll speak very briefly to the substantive evidence here because it helps frame the centrality of the judge's questioning at issue here. Mr. Swilley was tried alongside 3 co-defendants. 2 of his co-defendants were in fact implicated, to some extent at least, by physical evidence, either DNA or a fingerprint. The 3rd co-defendant, against whom there was no physical evidence, was acquitted. Mr. Swilley, the evidence against him was very weak. The prosecution's main expert wavered in his, the prosecution's star witness wavered in his identification of Mr. Swilley. There was no physical evidence against Mr. Swilley, and he presented a compelling alibi defense. The first part of that alibi defense were text messages that indicated, although certainly did not prove, that he wasn't at the crime scene. However, that alibi was completed by the testimony of his family members who attested that at the time of the shooting, he was with them. The judge's problematic questioning here targeted Mr. Swilley's family members, especially his main alibi witness, his grandfather, Philip Taylor. The judge also crossed the line in some of his questions to Mr. Swilley's grandmother and also to Joshua Colley, who was a friend of the victim. He was a friend of the victim but testified favorably for the defense. Moreover, in the middle of the prosecution's questioning of Mr. Swilley's sister, the judge jumped in and asked a classic adversarial question, which is, how do we know you're telling the truth today? Such questioning pierced the veil of judicial impartiality and led to a conviction despite strong evidence of Mr. Swilley's actual innocence. Should I have any time left, I will waive, and now I don't.
1 second.
So, perfect timing. I've got a question about your introduction. You indicated correctly that where the judge's conduct pierces the veil of impartiality, that they're entitled to a new trial, and then you went on to say, you went to Stevens and you described, and then you used the phrase, creating an appearance of bias. The first question is, in this case, do we have enough to say there's actual bias?
Judge, my short answer to that would be yes, and if I could explain.
Okay, no, that's fine. The next question I have is, under Stevens, is it actual bias, actual impropriety, or do you read Stevens as permitting a reversal for a showing of an appearance of bias or an appearance of impartiality?
So under Stevens, I believe, because in establishing the judicial conduct which warrants reversal, Stevens says there must be inquiry into the impact on the jury. I think that's looking at more than just alleged or apparent bias. I will, however, to fully answer the question, say that the distinction between apparent and actual bias, in my reply brief, I argued it's of no consequence, and I really wish I had cited to the U.S. Supreme Court case of Caperton v. Massey, because their words matter a lot more than mine. And in Justice Kennedy's opinion there, he makes it clear that inquiry into actual versus apparent bias is very problematic and really should be avoided, and it underscores the need for an objective standard. And I think that's the objective standard that the Stevens case came to, which is we should look at, is it reasonably likely that a jury would have perceived that the judge was indicating bias or partiality. Certainly that the prosecution took issue to a part of Stevens that I don't believe exists. It says that, in fact, if you look at the argument section of the prosecution's brief, I think it's the second sentence there which says Stevens holds this, and I think that's the wrong framing of Stevens. Stevens does not say there's structural error every time there's potential bias. Stevens says there's structural error where a judge's questions, regardless of whether it was because he truly was biased or simply because he appeared biased, when those affect the jury, structural constitutional error has occurred. If I can speak...
Could you just, I think that's really an important issue. Can you just please clarify that again? Obviously, when there's some purposeful bias or some manifest bias, that would seem to give rise to a structural error. And Stevens certainly, I think, asserted that point.
Yes.
But I'm having trouble understanding under what other circumstances is it structural error? In other words, an error that doesn't seem to require any demonstration of prejudice.
Sure.
Can you just make that very clear to me, if you would, please?
Absolutely. So under Stevens, the error itself is not established, regardless of whether it's structural or otherwise. The error is not established unless it is demonstrated there's a reasonable likelihood that the jury perceived the bias. So I think that is implicitly saying that there must have been some real-world enunciation of bias. It's not just, couldn't somebody on some day say that question was coming from a bad place? And that's not what Stevens is about. Is it reasonably likely that a jury would have perceived certain things? And I think in Mr. Taylor's questioning, I want to stress a few points that I think make that clear.
Can I ask you a related question before you go on that, and I'll cease and desist after this? What is the relevance in the Stevens case of its several references to the fact that the asserted error in that case was preserved? What is the relevance of that in terms of the structurality of various breaches on the part of the judge?
Justice Markman, I think to some extent that issue remains open. This court heard argument in the Chapman case last term where there was an unpreserved Stevens error and ultimately declined to issue an opinion and let the Court of Appeals opinion stand. I believe your dissent seemed to take that as an indication that the court is saying there's no distinction. I think it still remains unclear, the court not having spoken on that. And I think there's argument to be made that a preserved error should be treated differently than an unpreserved error. In this case, of course, at least with regard to Mr. Swilley, there are co-defendants whose cases I think are stayed in pending this argument. For Mr. Swilley, it is a preserved error. Counsel objected with regard to each of the witnesses, Mr. Taylor, Mr. Colley. And, I wouldn't take an opinion right now whether every unpreserved error should be structural or not. But one option the court would have would be to adjudicate this case, and certainly I see this case as one that warrants reversal. And then it would be welcome to grant leave in one of the other co-defendants' cases where it's the same error but it's unpreserved, I believe, in Mr. Granderson's case. So if I can speak to the judge's treatment of Mr. Taylor, I think this actually gets at a very important point of Stevens that was overlooked by the Court of Appeals in this case, and I think has been overlooked by other courts reviewing this. Stevens does not require or even envision that there be open hostility or open intimidation of witnesses. Of course, that would be enough, but I don't believe that's the standard. And I think the Court of Appeals read it that way. Instead, what the judge did here was he implied inconsistency in Mr. Taylor's testimony where there wasn't any. He was consistent on the point that he could not recall whether he paid his water bill that day or not. But when the judge was asking his questions, this wasn't even a question, this was simply a statement the judge made, which is, first he thought he paid it, now he didn't. And that's not it. He never said he thought he paid it. He said, maybe I did, maybe I didn't. Beyond implying inconsistency, the judge asked for proof that he had been to the bank that day. Now that, of course, is a side issue. Whether he went to the bank or not is not relevant. What's relevant is, was Mr. Swilley with him when he went to City Hall? And we know he went to City Hall because a notarized document proves he was at City Hall at the relevant time. But such a demand for proof would have emphasized to the jury that maybe the judge believes someone in Mr. Taylor's position, if he's being truthful, would have done something more, would have more proof. And the same thing applies to the judge's question about why didn't you come forward to the police if you're his alibi witness and he's so innocent. Now, there's a good answer to that. There's reason the prosecutor didn't ask that question. This is perfectly appropriate for the prosecutor to ask. Why didn't you come forward before? Here, the prosecutor didn't ask that because the question makes no sense. Mr. Swilley wasn't arrested till over a year after the crime. And the judge had a misconception about that, which his questioning of Mr. Taylor revealed. But again, that sort of question implies to the jury that maybe someone in Mr. Taylor's position is not credible unless he goes to the police on his own.
So is it the obligation of the judge, as he contemplates whether to ask a question, to inquire first, at least in his own mind, is this the kind of question that a prosecutor might otherwise ask? If it is, I better not ask that question. Is there some class of questions that's pretty much precluded to the court because it's, I think you used the phrase, the prosecutorial kind of question?
Sure.
And what is a prosecutorial kind of question as opposed to a judicial kind of question?
Sure, absolutely. You know, most of the time that I appear before trial judges, it's in an instance where there is no jury. It's on post-conviction motions. And there, of course, trial judges ask questions that are very prosecutorial, and they're welcome to do that. There's no jury. Exactly what the line is between a prosecutorial and non-prosecutorial question may be difficult. But I think anytime the judge is asking, how do we know you're telling the truth today? And that, again, happened in the middle of the prosecution's exam. He didn't wait till the end. I think that is a classic impeachment sort of question. So I think it's clear there are certain questions that a judge crosses the line on. And I think a judge, in their overall conduct, and certainly from all the guidance judges get from this court and the Stevens opinion, from the judicial canons, judges are supposed to have a different sort of mindset and a different sort of presence in the courtroom than the adversarial parties. And it's very important. One of the issues that I'll address here is the prosecution believes curative instructions in this case were either more substantive than in Stevens and Chapman, or that they should matter more. I think that is actually one of the misunderstood elements here. The curative instructions must actually be curative in nature, first of all. So I think the instructions that come in the opening before trial, I don't know how they're curative if they're coming before the conduct. They're helpful and they should be made. But in response to the objections, I think the comments the judge made were not curative instructions at all. What he says is, I've said this to them before, I'm going to say it again, I'm entitled to ask questions. Now that's a curious way to put it, because as this court said in Stevens, that was the same response the judge made in Stevens, and this court's opinion said, that seems to imply that this judge believes there's no boundaries to his right to ask questions. And moreover, that is being conveyed to the jury over and over. For all the jury knows, it's perfectly appropriate for a judge to ask hostile cross-examination type questions, when of course, generally it is not okay. But here the judge did that and then underscored it by saying he's permitted to do that. And if the court has no further questions, I will
You can
reserve my 2.5 minutes.
Well, is it wrong for the court to act in what I'll call a human manner and express disbelief at what somebody has said? In particular, in this case, there was some indication on the part of the court that it was skeptical or disbelieving of what I think it was witness Colley said concerning the fact that he didn't know whether or not photographs of certain hand signals were gang-related, and he
Sure.
was apparently a member of this gang organization. Does that come close to the line? Does it cross the line? Is it acceptable? I mean, I hate to ask the kind of question about something the judge said that was very discreet, but that seems to me to be emblematic of a larger type of question. Is there something wrong with a skeptical question being directed at a witness when the judge is genuinely and sincerely skeptical about what that witness is saying?
Your Honor, one of the categories of conduct or question the court is supposed to avoid is to express skepticism. That's correct. However, as I said, Stevens wouldn't warrant structural error reversal every time the judge may have expressed skepticism. It's about the overall conduct. And you brought up Colley, and I think that's a very important part of this to consider as well. Now, Colley's a witness that applies to the other defendants as well. Certainly, Josh Colley had things the court could question him about, and the court did. Expressed some skepticism about his motives, about his claims that he didn't have memory. But then the judge did not subject the prosecution's star witness to that same scrutiny when he was flawed in at least the exact same ways and probably more. At the end of his direct and cross exam, the judge asked not a single question to Mr. Youngblood. So that differential treatment that skepticism expressed only to one side, I think, crosses
Maybe
the
the
line.
judge just didn't agree with you on that ultimate premise, and maybe the judge also took into consideration that the examination and cross-examination of that particular witness was much more extensive than in the instance that we're talking about here. I mean, there's 101 different factors that come into play, and am I wrong in thinking the most important part of your answer is that we look at the totality of the circumstances?
We look at, absolutely, a stray comment here and there wouldn't do it, but certainly that's not what we have here. And I would push back on that a little bit. That, of course, is the argument that I'm sure opposing counsel will make, that maybe Youngblood had been impeached enough. Colley had been impeached enough. There's no doubt about that. There's a footnote in my brief where he gave the same answer, the same problematic answer, 12 times. So, that's a rough estimate. And the judge still chose to emphasize that in the last moments before he turned this witness over to the jury. So the last things he heard was kind of a recap. The last thing the jury heard was a recap of all the ways in which Mr. Colley is flawed. The judge chose not to subject Mr. Youngblood to that sort of scrutiny.
But the judge has a legitimate clarifying role in this questioning process. The purpose of questioning isn't just to allow the judge to opine and pontificate as he sees fit. It's designed to promote the pursuit of the truth in this process. So what's wrong with him trying to clarify something not in the form of a question, but in terms of the emphasis on some point? Sure. And you're right, the judge did seem to want to emphasize that point. But what if the judge felt that the emphasis of that point was necessary in order to communicate the importance of that point, or the relevance, or the particular relevance of that point?
So in a sense, of course, the heart of what you're asking is something judges do. Of course, they're allowed to clarify. But there's a difference between clarifying only certain points. This came up in the Chapman argument, where the judge was asking questions that seemed to just want to build up the prosecution's case, and he was trying to elaborate on the prosecution's case. To the extent that questions were asked of other witnesses here, that's exactly what they were, and that's a point I didn't get to make. But to answer your question, where the judge wishes to clarify, they're permitted to do so. But where there turns into a pattern of clarifying in quotes, which is really just highlighting the ways in which one side's testimony is impeached.
Isn't the idea that when the questioning reflects the judge's opinion about the evidence, that's when the judge has crossed the line?
I believe so, Justice.
Isn't it the genre that we're in? There's lots of different ways that can happen. One is if the judge asks your quote-unquote clarifying questions only of defense witnesses, constantly trying to clarify their testimony in ways that's helpful to the prosecution. That would be a way of a judge reflecting his disbelief in the defense case, right?
I think that's absolutely it. And that's why the treatment of different witnesses factor is very important. And I think that's another factor that was misstated by the Court of Appeals here. And there's some misunderstanding over that factor that I hope the judge will, that the court will clarify. Simply because other witnesses were asked questions does not mean that.
The other point, I guess, that shouldn't be lost in all this is the judge has the duty, I was a trial judge, to clarify certain very specific factual points if the testimony comes in a way that's confusing. But that doesn't lend itself to the judge asking, 10 or 15 pages of transcript questions of a witness and sort of taking over the lawyer's role in the case, does it? I mean, that alone tells us that the judge is taking on the role of an advocate, does it not?
I believe that's absolutely true. And then it becomes even more emphasized when the judge chooses to do that only with certain witnesses, and then we see a pattern that the ones he scrutinized, the ones he quote unquote was clarifying, but really showing things that they have already said they don't know or they don't remember, and he's only targeting those that support the defense. I think that's, again, just underscores why this is problematic.
So if the judge asks questions of the prosecution witness, or questions of the defense witness that arguably are rehabilitation questions, then everything's okay?
Again, Justice Zara, I think we have to look at the entire process. So if here he had aggressively questioned Willie Youngblood, then certainly I wouldn't come up here and claim that he treated Colley and Youngblood separately. I believe.
Does that put us in a position then of trying to determine how aggressive the Youngblood questioning was? Are we now trying to decide was he or she on the bench more aggressive towards the prosecution as opposed to the defense?
And that would be a difficult line to draw. In this case, though, he did not question Youngblood at all, and that's
I get it, but our opinions are like viruses. Once they're out there, they spread and grow to things you didn't think. And so We've talked about how he didn't do anything as it relates to the prosecution witnesses.
Yeah.
But if he did, does that save the case?
Save the case as in...
I mean, for them, if I've done this, if the judge says, all right, I've asked all these of the defense witnesses, I better start asking, when the opinion comes, I better start asking questions of the defense witness. And then the questions to the defense witnesses are, milquetoast as opposed to probing questions that the prosecutor would have asked.
And so certainly if the tables are turned, the prosecution could file a claim on, they have a right to a fair judge as everyone else does. But I think the answer, the core of your question really goes to, I think, the overall look at Stevens, which I think the Court of Appeals certainly didn't see. Stevens affirms the right of judges to ask questions, but this court's argument in Stevens and in Chapman shows that these opinions should lead judges to err on the side of truly evaluating whether a question needs to be asked, or is it something that will come out later, or if they're unsure, they can clarify with counsel before saying in front of the jury, because those things cannot be unsaid. So I think...
And again, something that didn't occur in this case, just trying to understand the implication of these issues. You just said, did this questioning in front of the jury, what if the judge excused the jury, asked the very same questions, and then allowed the prosecution, when the jury comes back, to follow the roadmap and ask the same questions? Now where are we at?
So it would be a different sort of judicial conduct at issue, and I think one that it would be harder to show any sort of bias there. It's not impossible, because as Stevens tells us, other conduct, such as giving tips to the prosecution that happened in one of the cases Stevens cited to, is also improper. So the court would look at, was this the judge truly inquiring into, are you going to ask about these things? And the prosecutor figures, okay, I should. Or was this more, he's coaching the prosecution, which of course he shouldn't do.
You somehow won the time lottery, but I don't want to cut off my colleagues, so I guess this is like a special, I have no idea what's happening right now. So.
Mr. Syed, in light of the fact that, as I think you're acknowledging in the course of the exchanges that you're having here, there are written and unwritten rules that a judge ought to abide by in this process. There's questions of tone and manner and temperament. There's a lot of nuances. There's a lot of things about which even the most conscientious and honorable judge would be uncertain about in the course of asking questions. Doesn't all this kind of elide into the conclusion that this is an area that's especially appropriate for harmless error analysis, because it's going to be not at all infrequent that there will be errors in the course of this process?
I disagree with that, Justice Markman. And I think part of the answer to your question is that there's a difference between errors that occur that the jury perceives and warrant reversal. There's a big difference between that and any sort of higher claim of judicial misconduct in terms of tenure commission proceedings. There's a big difference between that, and that's something I think the prosecutor's brief conflated. This sort of reversal will not happen frequently. I think most judges are perfectly comfortable asking the right sorts of questions.
Well, they'll be even more comfortable asking no questions at all, which is not necessarily what this rule is designed to achieve either, is it?
Absolutely, and if the court wanted to affirm the general right of judges to ask questions, I welcome the court to do that. I don't think that right is under fire, and honestly, I think there's no danger that judges will find themselves unfairly silenced. I think judges learn from this court's opinion, and it will be clear to them what areas they should cross into, what they shouldn't, what they should wait to let the parties sort out, and what isn't their business. I mean, it isn't the business of a judge to make either side's argument. Even if the judge thinks I, as the lawyer, might have inquired into something, it's not always their job to make sure that gets inquired into. So if there are no further questions, I will now sit down.
Enough already. Yeah,
Thank you very much.
Do I have to ask the same number of questions of this counsel? Sorry, I'll be careful.
Please stick to the softball type. May it please this court, Joseph Albasta appearing on behalf of the people. We're asking for the court to deny the appellant's application and affirm the Court of Appeals decision in this case. In reviewing this case under the totality of circumstances test, in People versus Stevens, there's 5 things to consider: the nature of the judicial conduct, and in this case, we are talking about questions that the judge asked of the witnesses. And one thing the lower court found important is this judge did not ask questions of only these 3 witnesses that the appellant brings up. He asked questions of 19 witnesses in this case, and I believe there were 37 total. So he asked questions of about half of the witnesses that were presented in this case. And he didn't restrict it to just ones that were favorable for the defense and favorable for the prosecution. There was a witness, can't think of her name off the top of my head. She had owned the car. He asked her quite a few questions about her drug use and her purposes for loaning this car, which were not cut favorable towards her credibility. Specifically, typically this trial judge reserved his questions until all the attorneys had finished asking their questions in the cross-examinations, and then he turned it over to the jurors. And the jurors, in this case, had quite a few questions of these witnesses as well. The court also has to look at the tone and demeanor in the courtroom, and that can be difficult based on just having a paper record. We don't have video, we don't have audio in this case. But there's no evidence on the record that the judge was raising his voice or demeaning or belittling the witnesses. At least there's none present in the objections that were offered by counsel. The court must then look at the scope and the context and the length and complexity of the trial. In this case, we had 4 co-defendants. There were 5 attorneys. It involved conspiracy charges, homicide charges. The trial lasted 18 days in court. It started on September 9th and ended on October 9th, so it ran a full month. And there were issues involving real property, and that's not typical of a criminal case. So you had criminal attorneys trying to elicit questions regarding the transfer of a deed and a quitclaim deed in this case. So I think the judge's questions of Mr. Taylor were appropriate because his testimony was confusing and involved an issue of transfer of property, which is not typically any of these attorneys' area of interest. They're criminal defense and prosecuting attorneys. The court must also then look at whether the judge's questions were directed to one side more than the other, and I know all of you have reviewed the trial transcripts and been able to see that. And then also look at the curative instructions that were given. In this case, there was a instruction given in the preliminary instructions, in the closing instructions, and then 4 times during the trial when the judge did ask questions of these witnesses. I would waive any further free fire time.
Do you think the judge's questioning here reflected his opinion about the evidence?
I don't think it did.
Do you think the judge was skeptical of some of the testimony that's at issue here today?
I think the judge was skeptical of some of the testimony that was at issue today. In looking at...
So how is it that you're able to make that conclusion, but the jury was not?
Well, I clerked for this judge for 2.5 years, so I do have some personal experience with this trial judge. But in looking at his questions, the skepticism that arrives with Mr. Cowley, he was forced to be there under court order. He was not willing to appear as a witness, and he had given statements earlier to the police concerning details of the crime, and then when the prosecutor asked him questions, I don't know, I blacked out. I don't remember.
I wouldn't quibble with you that there are reasons to be skeptical of the witness's testimony, but that's why I asked a different question, whether...
I'm sorry, I may have misunderstood.
Yeah, no, I wouldn't argue with you that there are reasons why the testimony could be attacked. The question here we're trying to determine is whether that's the judge's job or whether that's the prosecutor's job.
Well, I think the judge has a duty to ask clarifying questions when there are some answers that don't seem to jive up with each other. Mr. Taylor's testimony was an example of that. He gave a couple different conflicting time frames as to when this alibi was taking place, and I think the judge was trying to clarify that because...
Should the judge have a cross-examination outline and sort of be checking off if the prosecutor doesn't ask these questions or the defense attorney for that matter, then it's the judge's job to jump in and do some cross-examination?
No, but I think if the judge does have questions in his mind as to what's unclear, he or she wants to make a clear record as to what's occurring in his courtroom. And perhaps he wants to do that to save time in a case that's going on of a considerable length and number of days, bringing a jury in day after day after day.
Is it fair to say that the questions, in large part, were the type of questions you'd expect from the prosecutor?
Well, I think they are. But as a prosecutor, my job is to present a clear case to the jury. And the defense attorney's job is to try to muddy that up as much as possible. So by its very nature, if the court is asking questions to clarify evidence, they are, by that nature, going to be favoring the prosecution in that case.
So all judicial questions necessarily, sort of by definition, will be prosecutorial-friendly questions?
Not necessarily, Chief Justice. I think in a lot of cases they will be. Because if you've got people that are muddying up the water and the judge is trying to clear up an issue in his own mind, clearing up that issue might favor the prosecutor in that sense. And I think typically it probably will.
Is this a normal amount of questioning in your view for a judge, or is this more than what we normally would see? Certainly in my experience, in my own experience as a trial judge, it goes far beyond anything I ever did. So maybe I was, a meek little mouse on the bench, but does this go more beyond what we would normally expect to see?
Well, having clerked for this judge personally, I did see him ask a lot of questions during trials. And I know in trials that I know you have experience with this judge, and I'm not trying to single him out. Is this just in general, is this what we should expect to see? Is this normal, or is this a case, an extreme example? I don't think it's an extreme example. I know many of the trials I've conducted, I see a fair amount of judicial questions. Now, it does depend on the judge. Some judges will sit up there and say nothing other than the instructions and rulings on objections. Other judges in my area are, I don't want to say active participants, but will ask questions if there's a point that isn't clear to them.
Accepting the premise for a moment that the judge's questioning here was excessive and aggressive and condescending and skeptical, what is your best argument, nonetheless, that it wasn't reflective of actual bias, but at the most an appearance of impropriety?
Well, I think that would be that he did question almost half the witnesses in this case. He didn't keep his questions solely to ones that favored the defense or the prosecutor. He asked quite a few questions. I believe it was Officer Bayerlein. He asked 14 or 15 pages of questions, I believe, trying to clarify the timeline there. So to me, it seems there's no actual bias shown in this case. If there was any, it was apparent, but I still don't concede that either.
I'm confused about why you think that distinction matters so much given Caperton or Caperton. I always pronounced it Caperton, and then Mr. Syed pronounced it Caperton, and he probably knows better than I do. So why is that distinction meaningful in a constitutional sense? Why isn't apparent bias just as meaningful?
I don't know if it is. I don't know if it is, Justice. If someone is deprived of the right of a fair trial, I think there should be a reversal in that case. I don't think that occurred here, but I think if it is found that a judge has pierced that veil of impartiality, I think reversal is required. Personally, I think if the defendant did not receive a fair trial because of apparent or direct bias by the judge, I think it should be reversed.
I appreciate that answer. Thank you.
So you believe, in summary, that in either circumstance, there should be no attempt to assess the actual prejudice that was done to the defendant?
I think so, Justice. I would concede that point.
You would concede or wouldn't concede?
I would. I'm sorry. My job is not to get a conviction when I'm up there doing a trial. My job is to see that justice is done, and if the judge is acting with an air of bias, whether it be apparent or direct, I think the case should be reversed. I think the judge should recuse himself in that situation where that occurs. I think there is some difference, and I think my colleague who wrote the brief in this case brought this up with regards to
Yeah.
Stephen. The term misconduct might be a little harsh if we're looking at like a judge making a mistake, as opposed to a judge who is getting in there and actively, pounding on a witness, or some of the comments that are present in some of the other cases where they're telling witnesses not to waste their time, or even belittling an expert witness like they did in the Stevens case. I think that's going a lot further out of their way, and I think there should be a distinction between misconduct and error in that regard.
Just, you mean in terms of sort of terminology?
Yeah,
understand.
I look at the People versus Cooper case where the Court of Appeals decided to distinguish, it's not always prosecutorial misconduct, there is prosecutorial error and prosecutorial misconduct, and misconduct seems to imply that there's fraud or something illegal going on, whereas error shows that Joe made a mistake while he was in trial.
I understand. I have like a lot of sympathy for that, but it's a little bit awkward because it's a judicial term of art, obviously. So, there are all these other, jurisdictions that use the term of art, and it's a little bit odd for us to use a different one, but I hear you, and I appreciate that.
Okay.
So I just want to make sure you use the word apparent. Actual bias, apparent bias, is that the same as an appearance of impropriety? You would suggest that it would be reversed if we conclude that there is an appearance of impropriety in this questioning? Is that your concession?
I don't know if we're treating appearance of impropriety and apparent bias as the same in this case.
Well, what is apparent bias as opposed to actual bias?
I think apparent bias would be more where a judge shows some shock and disbelief to a statement that we all might feel, and they've accidentally let that come through. Whereas something shocking comes out of the witness stand, and the judge just kind of, as a human being, is, what?
I heard your opposing counsel and concluded that the opposing counsel believes that where it is reasonably likely the jury perceived actual bias, that there needs to be a reversal. So I'm not sure that reasonably likely the jury perceived actual bias is the same as an appearance of bias or an appearance of impropriety, and I don't know if that's what apparent bias means. Can you help me? Do you agree that reasonably likely the jury perceived actual bias is a standard that's applicable?
Can you repeat that for me?
Reasonably likely the jury perceived actual bias. Or let's even take out the word actual. Reasonably likely the jury perceived the judge was biased.
I can't give you a good answer on that. I'm sorry.
Okay, thank you.
Well, counsel, if any error, misconduct, or otherwise is structural, and we don't engage in a harmless error analysis, can I ask you the same question I asked opposing counsel? Why was there some emphasis in Stevens on the fact that the defects in questioning in that case had been preserved?
I think it's important that it would be preserved. And I think one of the reasons why is it may be the defense attorney or the prosecutor, depending on who's objecting to it, may have reasons for wanting that question asked and may decide not to make an objection at that point in time. And they would do so at their own peril by not making the objection to preserve it. It's always tough to be in that situation to object to what a judge is doing, because it may have impact on your future rulings throughout the case. But I think if it's not preserved, I think the court should consider that perhaps the defense attorney or the prosecutor had reasons to not object to that judge's questions, but did so at their own peril, and therefore I think it should be a little different standard with preserved versus unpreserved error.
Thank you, counsel.
Thank you.
Mr. Syed, I know you tried to reserve, but we just gave you so much extra time, I'm calling it. It's over. Thank you very much. The case will be submitted.